Good afternoon, everyone. Thank you very much for joining us for the 6th episode of the DISSECT Project's Talking Evidence YouTube series. So the DISSECT project is an ERC-funded research project under the direction of Marie-Bénédicte Dembour, and it examines the role of evidence in international human rights adjudication. Today's episode is about the use of the evidentiary standard of proof of beyond reasonable doubt at the European Court of Human Rights. So we'll discuss the court's interpretation of this standard, its use in the case law, as well as a more critical perspective regarding its appropriateness for human rights adjudication. I'm Isabella Leroy. I'm a postdoctoral research on the project, and I will be chairing the discussion between Dr. Christine Bicknell and Professor Marie-Bénédicte Dembour. So Christine is a public international lawyer with research focus on international human rights law and European human rights law. She has experience in the prohibition and prevention of torture and cruel, inhuman and degrading treatment across different detention settings and legal systems. She's also recently written about the EU accession to the ECtHR and the challenges that might pose. But for the purpose of today, she's also written an article titled Uncertain Certainty, Making Sense of the European Court of Human Rights Standard of Proof. And Marie is a professor at Ghent University and is the PI of the DISSECT project. And of course, she's written extensively about evidence, including an article from 2023 titled Beyond Reasonable Doubt at its Worst, but also at its Potential Best, Dissecting Ireland versus the United Kingdom's no torture finding. So thank you both of you for being here to discuss this issue. So to get us started, I want to ask both of you why it matters to discuss standards of proof today, and in particular, why does it matter to discuss the beyond reasonable doubt standard at the European Court of Human Rights? Marie, do you want to start us off?
Okay. It's extremely important a topic. Of course, I would say that, given the title of the research project that I am leading at the moment. But I think in the course of executing the project, I have come to be far more persuaded by the fact that we need to use standards of proof in international human rights adjudication. That is not necessarily a given because the very concept of standard of proof is a common law tradition concept. Civil law lawyers don't refer to standards of proof. They talk about the intime conviction du juge, so the inner conviction of the judge. So in the civil law tradition, if the judge is convinced of the facts, that's enough. And of course, we can be convinced of a fact, extremely strongly or so, but nonetheless a little bit more than not. And what I have come to realize, in a sense, is that if we do not name the standards of proof, which are applicable during proceedings before an international human rights court, it's problematic because then it's not clear it's not clear what level of persuasion should be reached. It can be anything. It can be a little persuasion or a very serious persuasion. And it means that cases may be adjudicated on the wrong basis, because sometimes it's very important that there is reasonable certainty about a particular fact, but sometimes this would be an unreasonable expectation, which would then, if it is applied, lead to refuse to consider as established facts which actually have happened, and thus lead to impunity. and lack of accountability. So it's very important that we talk about standards of proof. It's also very important that we talk about beyond reasonable doubt, because it's the standard that the European Court of Human Rights has said that it was adopting. And so, yeah, there are some exceptions, but they're not very nicely understood or even conceptualized by the court itself. And so I think this is an area which really is begging for conceptual clarity as well as for practical consistency.
Yeah, if I may, I completely agree with that. And we're obviously not, you're talking about standards of proof before getting into which standard of proof we'd be referring to as the best or most appropriate. And we'll have a conversation, I'm sure, in a bit about whether the European Court of Human Rights has more than one standard of proof. It has a declared standard of proof, which is beyond reasonable doubt standard. But we'll get into the meat of that in a bit. I agree, rather than having this loosely framed sort of the way that a judge is or judges are persuaded, you have, by setting or having a declared standard of proof, there's an attempt to have a more objective approach to this, in sort of at least setting out, well, this is what is meant by this is the extent to which the judge or the judges are persuaded, and then you can expect, and it's right to expect, a more consistent, I think, approach through the case law as cases have been decided. And why it's important, I mean, this is the distinction, the difference between whether a violation is found or whether it isn't. So actually, what threshold do the facts of the case need to be proven? Now, in terms of proving fact, and I know that we'll get into that, it's important to recognise, I think, that the European Court of Human Rights itself is not a court of first instance. And so usually fact doesn't come into the matter. That's established within the nation states before it gets that far. But sometimes, and that is where and you'll know this is where the court does start to then engage sometimes in this approach where it has to establish facts to be able to decide the case. But still, this whole idea of how persuaded the court has to be of the facts, and then subsequently that there has been a violation, I think is vitally important. So knowing what that standard is, and there's the normative question of what that standard should be, because we also need to think about that. I think it's vitally important. It's the difference between, as you said, impunity or not. So actually, how would the court appropriately approach that? But also recognising, and I think we'll tease this out in the discussion, that there's a power dynamic here, that the states are in a much more favourable position than the applicants in these kind of cases. And that's something that is deeply relevant when we're talking about the beyond reasonable doubt standard, because we'll start to get into, well, who needs to do the proving to meet that standard? And that is vitally important. So.
Right. So it's clear that the standard that having clear standards of proof is important for human rights adjudication. And Marie, you've touched on the fact that beyond reasonable doubt is a standard that exists, particularly in common law. However, I think you both defend the idea that beyond reasonable doubt is actually an autonomous concept in the European Court of Human Rights, and that the court doesn't conceptualize beyond reasonable doubt the same way that common law jurisdictions would. So I guess here the question is, what does beyond reasonable doubt mean in the context of the European Court of Human Rights, if it doesn't mean what it would mean in a common law jurisdiction? Christine, do you want to start us off?
Yeah, of course. I think I and Marie have both separately indicated that, well, actually, there's kind of this standalone autonomous concept that we could label this as an autonomous concept, where the European Court of Human Rights is setting out its standard of proof is, and it claims to only have one, but where it declares its standard of proof, that is declared as being beyond reasonable doubt. So very high threshold that has to be met. There are, however, particularly where a state is being uncooperative in process, maybe has access to more facts than the court or the applicant, which would be relevant to that case. Then if you're finding that a state is being uncooperative, we have the possibility, and the court does this, that it will reverse the burden of proof. So this idea of burden, who must do the proving, is inherently connected to the idea of what's the standard and to what degree must one prove it. And I think in Professor Dembour's piece on Ireland, you bring out very well this distinction between the approach that you would have in the common law as opposed to the civil law traditions to this. But within the European Court of Human Rights system, we can't. It's the degree to which the court is persuaded, but they are willing to take into account, so we're willing to reverse that burden for a start. So actually, we've got so much evidence, or the court, and or the state isn't helping us to provide other evidence. They might then make a presumption in favor of the applicant, which is a rebuttable presumption. So you have then the state is able to demonstrate or not that presumption is incorrect. But that's not, I suppose, how in a national jurisdiction beyond reasonable doubt standard might be understood, but it is how the court conceives of it. And when you look through the case law, and I'm going to park as an exception, actually, the Ireland case, which Professor Dembour goes into a lot of detail on there. But with the majority of cases where we see this, the court actually is establishing to a really, really high degree of certainty. And so actually, it leaves almost no room for doubt. But they are, and there is an instance where actually constructive knowledge is brought in the rendition cases, for example, which may not, if somebody's liberty is on the line, as in a criminal case, within a common law tradition, that might not be acceptable. But here it's about whether the state has violated rights or not, and so that it has its own unique understanding of that that standard, and so I think that's important to have that in mind, because where the court has come under criticism for maybe not meeting that beyond reasonable doubt standard, that is generally because it's being compared to the beyond reasonable doubt standard in a different jurisdiction or in a different context, which, actually, as long as the court is true to its own conception and understanding, and very upfront about its understanding of this beyond reasonable doubt standard, then I think that's acceptable, because you still then would get the certainty of knowing what the court is looking for, and that is, I think, vitally important that's there.
Yeah, maybe I'll come in, and one thing for the non-common law lawyers important to possibly understand is that in the common law tradition, there are two main standards which are being recognized, two main standards of proof. One is beyond reasonable doubt, and the other one is balance of probabilities. And beyond reasonable doubt is the one which is being used in the criminal cases. And it's there, in a sense, to protect the accused, because it's the prosecution which needs to prove the case beyond reasonable doubt. And as Christine already said, this is a very, very high standard. Basically, it needs to be virtually certain. And virtually, but it's like 99.99% certain. There cannot remain reasonable doubt. And if there remains a doubt, then the accused theoretically cannot be found guilty. So that's, in a sense, reinforcing the presumption of innocence. And obviously, there the standard works in favor of the accused and to the detriment of the prosecution. Because if the prosecution does not manage to prove beyond reasonable doubt, then the case falls. In civil proceedings, the standard goes down. It's probabilities. It's called in different ways. It can be called the balance of probabilities. It can be called the preponderance of evidence. It can be called more likely than not. In general, commentators will say, okay, 51% of certainty is enough. Of course, we can never rate exactly what is 50 or 51 or 53 or 42 or 60, but it's giving the idea. If it's more likely than not, the facts are considered established. Now, in the European Court of Human Rights, the court has said right from the beginning, we're going to use beyond reasonable doubt. Actually, the first case where this was established by the court is called Ireland against the United Kingdom, and it's about the application of the 5 techniques of sensory deprivation to IRA presumed members, and the question was it torture? And the court answered, no, it was not torture, it was inhuman and degrading treatment. The Commission, because at the time there was the European Commission of Human Rights, which was the first body where a case would be looked at, the Commission, all Commission members thought that it was torture beyond reasonable doubt. So it was a unanimous opinion. The court said we're going to use beyond reasonable doubt. It immediately said, after naming that standard, it said, but we're going to accept that beyond reasonable doubt can be met through strong inferences and presumptions. And then it also added, and actually, in terms of this presumption, we are going to look at the behavior of the state, being normally the respondent state. And the implication was that if you have a respondent state who is being alleged to have violated human rights, who then does not share what it knows about the incident, and normally, as Christine has already said, the state will be in a better position to access evidence than the applicant. If the state doesn't share that information, well, there will be questions which are going to be raised. Why is the state not doing this? It's suspicious. So the suspicion will, in a sense, feed into a presumption against the state. That is the theory. Now, there are 2 things. One is that whether presumptions and inferences are used in the common law for criminal cases, well, I've tried to talk to a number of criminal lawyers. They tend to say yes. But nonetheless, the idea of beyond reasonable doubt in the common law tradition would be that you know the facts. There is no reasonable doubt. So yes, you can use inferences, but there need to be a very, very strong basis nonetheless. In the European Court of Human Rights, the European Court said, upfront, we will be using presumption and inferences. Very, very important, as we've said it a number of times. If I have been tortured, well, it's very unlikely that the person who has tortured me will say, yeah, she's right. We did this treatment. It will be the opposite. There will be an attempt by the authorities to suppress any evidence. So if you ask for beyond reasonable doubt evidence to be brought for, cases of serious violation of human rights, they're all going to fall, because the more serious the violation, the less likely the state is going to own up to it. So it was very, very, I mentioned torture, but we could use for enforced disappearances is another case. Of course, the killing of opponents, very, very serious violations. So the court was obviously aware of that, and so that's why it said that it would accept inferences and presumptions as a method of proof, which maybe we'll discuss that later. But I think there is a very, very good rationale for saying that presumption and inference in some cases are extremely strong proof. It becomes beyond reasonable doubt. At the same time, I think it's very, very important that in human rights law, in human rights adjudication, sometimes the adjudicatory body is going to accept that there is a violation, even though maybe it does not feel like it has been proven beyond reasonable doubt. Because if you don't do that, as already we have said many, many times, it means impunity for the violating state. So to answer your question, Isabella, yes, it's an autonomous concept. What that means is that it's a concept which the court develops for its own purposes, according to its own understanding, without having to pay attention and pay regard to what other jurisdictions, for example, national criminal law jurisdictions, understand by beyond reasonable doubt. Beyond reasonable doubt at Strasbourg does not need to be beyond reasonable doubt in the UK or in wherever in the world. It's a concept which the court can develop for itself. So it has, in a sense, done that right from the beginning. As I said, it said we will accept inferences and presumptions. It said that in Ireland versus UK. But then, and that's where there can be problems, the court did not apply its principle. And even though there would have been lots of scope for having presumption and inferences, the court said, we don't know anything about this. We don't know that it was really bad. We don't know that there was intense suffering. There has been no proof of it. And so it didn't find there was torture. As I already said, the commission came up to the opposite conclusion, having interviewed a number of people, having done a very strong investigation, and unanimously said, well, this was torture. Beyond reasonable doubt, it was torture. So what I want to say, and maybe we'll come back to that later, is that I don't think the court is consistent with the way it uses the standard beyond reasonable doubt. It's consistent in what it says about it explicitly, normatively, when it gives a principle, but it's definitely not consistent in its interpretation and application of it, which I think is then very problematic because, as said before, it says it accepts inferences and presumptions, but then it does not always accept it. And then it refuses to find states in violations of human rights, when I certainly believe, and I'm not the only one, that there should have been a violation being declared.
So you've both, before we move on, you've both discussed a little bit the idea of inferences and presumptions, particularly the presumption that arises when a state is not cooperating in giving access to key evidence. So what do you mean exactly by inferences and presumptions? And maybe can you give an example?
Okay, I think maybe there is a hint for me there. To also, I've tried to explain to my students or to readership of an article why do I say that an inference can be a proof beyond reasonable doubt, whilst many people would say, well, if it's an inference, it's not concrete, it's not solid evidence, it's not a proof. And I've come up with the following example, which is, my front door of my house is painted blue. I know it's blue. If I come one day, having been away for a week, and I arrive home and it's now yellow, well, something has changed. So at least something has changed. For sure, something has happened. If the door in all other respects is exactly the same, I recognize the handle, I recognize the hole somewhere, I recognize the whatever there is on my door, and it's exactly the same, except that it has become yellow, I will infer that it's been repainted. And I think that if I have evidence of what the door was like to begin with and what it is now, this is proof beyond reasonable doubt, even though I have not seen the act of repainting taking place. And possibly nobody has seen it, nobody has testified to it. I only have the inference. But as far as I'm concerned, this is proof beyond reasonable doubt. And so I think that in such cases, refusing to draw the inference becomes a refusal to see the reality, to accept the reality, to acknowledge the reality. And that's why I also say that sometimes the European Court of Human Rights, by not drawing inferences and kind of saying, oh, we need things to be proven beyond reasonable doubt, it becomes a trick to refuse to acknowledge what states have done, because the court is under huge pressure from states. We know that there are backlash from state. I mean, the United Kingdom is very well known about that. It's always threatening to leave the convention system, saying that the court is going too far. And so I think that, in a sense, the evidentiary, both principles and application, become part of these political developments. This is not the best word, but political. I mean, I don't like to use the word game because it's too serious. But in a sense, these politics which are being played out at the court.
If I may, where we have that in presumptions and inferences being made, I just want to add that this is primarily, we're talking about where Articles 2 and 3 are at issue. We're talking about disappearances, we're talking about life, we're talking about torture, which is, I think, has already been said, to a point, because this is where states will then start to be very uncooperative and very obstructive in the provision of any relevant evidence. Now, in the sort of the rendition cases and some of the cases against, I think, Bulgaria, for example, where with the inhuman and degrading treatment by virtue of detention conditions, you have actually quite a strong triangulation of evidence. So going with the rendition stuff, and this is more recent, I suppose, but then obviously the 1978 case of Ireland obviously came back again to try and have that revisited. But with that, and I can see how this plays into perhaps the political context, and maybe there's less for the court to lose on this, but they're taking, you know, such level of detail as having flight logs and knowing that a person was on a particular flight and all these kind of pieces of information, and yet they still actually reverse the burden of proof, the who must do the proving, you know, and then place this rebuttable presumption on the state. Well, we think actually that this has happened, and the degree of rigor that went into those particular cases is quite astonishing, but actually, you know, what's happened in Ireland, and I've read the paper and I think it's fantastic, is actually there seems to be the court knowing about particular evidence, but if I understand correctly, not actually putting it into or articulating it in the judgment, which I think is where we run into Professor Dembour's argument about, well, we have beyond reasonable doubt standard. As a concept, this may be fine, and we still need to talk about, well, is that the right standard to be applying here? And I've changed my view on that, actually. It might be very useful, particularly because of the pressures that come to bear, the political pressures from states on the court. Actually, if it has such a rigorous and exacting standard and it's meeting it properly, then actually that's brilliant for its credibility of particular judgments, but also as a court and its legitimacy. And, you know, it is a good argument, you know, against you know, states that want to put it under pressure. But from your paper, you talk about sort of the virtuous use of the beyond reasonable doubt standard and disingenuous use, which is where actually, consciously or otherwise, and I think you're very fair to, you know, some judges might not actually have realized what was going on and done this consciously, but sidelining certain evidence, such as we're seeing, you know, medics saying we're seeing, you know, people who are behaving in the same way as people who'd been tortured by the Nazis, and then the court going, oh, that's not what, just sidelining it, and that's the disingenuous use that I think you're drawing out in your paper. And I think this is a really important point to emphasize, because there needs to be the standard, and then there needs to be this consistent application of the standard, without which then the credibility point can't withstand, and that's you know, that's problematic. So I think you know, I've forgotten what you actually asked me about. Presumptions, but you know, in some circumstances where the presumptions are there, it already looks, rendition stuff, it already looks on the face of it, well, this is proven, but they're still giving the opportunity to the state to go, well, actually, you tell us it's not. And then when they can't, oh, actually, do you know what? You've met your beyond reasonable doubt standard. And so that's where we are with that. But that's when it's being used properly.
One
Follow-up?
Not follow-up, no. Whatever it is. It's not only sidelining that the court was doing. It's actually completely erasing. And I mean, to me, that was extremely shocking. That the court, in its judgment of 1978 in Ireland versus UK, does not mention the expert evidence of two medical doctors whom, as you say, told the commission, actually, we have examined this man and we testify to you that the long-term effects they are suffering from are as strong as the long-term effects of torture suffered by the victims of the Nazi regime. And to me, that is very, very important because, of course, in a sense, Nazism was the reference. I mean, the Nazis were doing the thing that was abominable and that could not be done again. This is why we have the convention. And for the court just not to engage with it at all, to do as if it was not there. While, of course, I mean, they cannot not have known that it was there. So that to me was extremely shocking. The erasure of evidence. So that was one thing I wanted to add. And I mean, the other things is that I'm not absolutely sure that I think that beyond reasonable doubt impact is only applies, that it only applies to Article 2, right of life, Article 3, inhuman degrading treatment and punishment and torture. Of course, it's very striking there, but I was trying to think as you were. Of course, there is also, for example, racial discrimination. We have the same phenomenon. I was thinking possibly of pushbacks as well, but of course, you could say it's Article 2, Article 3. But I think there will be probably other spaces. I don't have an example as such, but I could imagine that for protest and the right of association, there would also be beyond reasonable doubt, which can be used which can be used disingenuously by the court. That's when the court, in a sense, hides behind the fact that there wouldn't be enough evidence to manage to let the state off the hook. Now, I also agree with you, and of course I've put that in my article, that there is a genuine good application of beyond reasonable doubt, because in its good use of it, with presumptions and inferences being accepted, because otherwise it's often too difficult for the applicant to manage to prove the case. But with that proviso, then it gives a solidity to the case law and to the findings of the court. So I agree that the court cannot flimsily declare a violation of, especially Article 2 and Article 3, but even the other ones. So to me, in a sense, I had not expected to do that at the beginning that I was writing the article. But by the end of it, I say, okay, we should keep, the European Court of Human Rights should keep beyond reasonable doubt, because partly, if we ask the court now to change, it won't do it. I mean, it's too entrenched. I mean, it would be, but let's do it in a way that reinforces the good side of beyond reasonable doubt, which, by the way, has not been adopted by the other courts of human rights. So the other courts of human rights, I think, they're quite clear. This is too high a standard for human rights law. Let's not take that one. But that's the one we have in the European system, and we can work with it. But it does it would have to entail that the court uses it in a human rights perspective. And as far as I'm concerned, it's dramatic that it does not always do that.
If I may, so looking at the court as having its own sort of beyond reasonable doubt as an autonomous concept, in the cases where it refers to its standard of proof, this is very much, that is the territory of 2 and 3, and I completely accept what you're saying about racial discrimination and maybe application elsewhere. But this is, I think, why it's important to get some clarity on where the court is applying this, to what kinds of cases, as well as what's acceptable, what its interpretation of that standard, and what's acceptable to the court to meet that particular standard of proof. And I think you're saying about pushbacks, and I think that's something I would like us to maybe explore further, kind of this future looking point, since the European Union is hoped or intended to join the European Court of Human Rights, or the European Convention system. Things like pushbacks and the involvement of Frontex, where we have in that context where European Union is in some way involved at the moment, because states have to recognise mutual trust, mutual recognition. But at that point in time, should they become party to the convention, Frontex has involvement in pushbacks. And so to look in a future looking way, currently there's this Bosphorus presumption of equivalence in protection of the rights. For what you're saying about this potential for disingenuous use of beyond reasonable doubt standard, would that presumption just apply still to the European Union or its institutions in that kind of context, for maybe undeclared but still perhaps some kind of underlying political reason? And I'm conscious of this whole dimension that you've brought to light with the Ireland case, and suggesting, well, actually it's kind of a wider kind of almost political consideration. But actually I can see in a future looking kind of way that this is still relevant and important to actually be conscious of. I hope that we can perhaps tease that out a little bit.
I mean, following on what you've just said, one thing which strikes me is that, I mean, here we've been talking of presumptions and inferences which are rather going against the state, which are rather pointing towards the state having violating the convention. But in fact, there is a presumption which is at the heart of the European Court's jurisprudence, which goes in the other direction. It's that it's the presumption that the state acts in good faith, and that the state, in a sense, doesn't lie, even when, the state has accepted explanations from states, which you kind of think, on which planet do these judges live? So that is also, to me, that's a very strong concern. So if we take the example, one of the leading cases on pushback, ND and NT against Spain, the court has come up to accept that the applicants would have been able to access a consulate, and didn't need to climb the wall, the fence, very high fence, between Morocco and the Spanish enclave of Melilla. So the court basically says, well, whatever bad happened to them, it's their own fault, because instead of climbing this fence and being pushed back, they should have applied for a visa at the consulate. And the court says that on the basis of the Spanish state having declared during the hearing at the court that there was a possibility. The UNHCR said to the court, it's impossible. No applicant can reach that consulate. It was closed. There was nothing. It was not only the UNHCR saying that. There were a number of there were also NGOs saying that. There was the applicant saying it, the applicant's legal representatives. So, and the court just accepts it. Good faith from the state. while really nobody else was supporting this fantasy that this consulate was approachable, accessible. And I mean, this is another example of for me, where the court really invents facts.
Yeah, I think that case is obviously been criticised a lot. So ND and NT, just for anyone making notes, but in that case also I found it astonishing that the way it is framed is there's a right for states, now I'm paraphrasing, but a right for states to defend their borders actually is introduced before the right of the individual people who are obviously trying to access Spanish territory to claim asylum. So it again, the framing seems a bit peculiar because the state is put first in that particular judgment, and so I think you're absolutely completely onto something with this, but it's a little bit depressing at the same time. And I think again we need to sort of situate the court within its context, perhaps, and this is why we've got that open letter that was written. Where states are going, well, actually, we need to have greater freedom to again defend our borders. This is the running theme at the moment. But rather than yield to that, perhaps the court needs to have this rigorous and exacting standard of proof and apply it consistently. And I think that in terms of credibility of the court, because the argument in that open letter is obviously about extending and expanding the scope of the rights and states pushing back on that, but in this context the degree or extent to which we need to still talk about what is being proven, but the case is being proven based on the facts being proven, and having that exacting standard at least reinforces the credibility and the legitimacy of judgments as they come through. But it would need to be a consistent and rigorous application of the standard. So there's two things here, aren't there? The standard itself and understanding, conceptualizing that standard, and then having consistently and appropriately applied, which you're demonstrating isn't always necessarily the case.
Yeah. What I find interesting, following up from what you are saying, is that there is one scenario where the court says to the state, you must demonstrate what you are telling me beyond reasonable doubt. And that's the use of lethal force, where the court says the explanation must be beyond reasonable doubt. And of course, I completely approve of it. You can see why the state should be able to prove to the court beyond reasonable doubt, of course, being yet again understood as comprising presumptions and inferences which are strong, that the state should be able to say, well, we used force because this, and that. And, at that moment in time, we really were justified in using lethal force. Of course, very relevant at the moment with what's happening in the States. But what I also, and we've not talked about that, and we probably don't have time to go into it now, but it will be hopefully for another episode, Isabella. When there is a shift in the burden of proof, the state has to bring an explanation, and the court says it has to be a plausible explanation. Of course, the word plausible is not very high, and I cannot help wondering why the court sometimes does not ask for something much stronger from the state. It should not be good enough to have rebutted the allegation, just which seemed prima facie plausible from the applicant, to have the state rebutted just through something that it says, and that the court accepts it would be saying in good faith. And here, I have the example that I've commented upon of PH versus Bulgaria, which is a case brought by a young Roma woman who had been taken to the police station on very strong suspicion. Maybe it was almost also, I don't know the details, but possibly it was almost beyond reasonable doubt that she had she had stolen something in a mall. So she's at the station. She's going to be released to be judged later on, and she asks to go to the toilet, and she's taken to the second floor. And there she goes to the toilet. She doesn't come back because she has jumped from the window 2 floors up. And the court accepts well, of course, there is a suspicion against the state. Entered in good health, leave in a coma, seriously injured, suspicion against the state. The state says, oh, it was an escape attempt. And I'm like, it was an escape attempt? Really? Jumping from that high? How does the court accept that? And it accepts it. So there. It's still fine that the state should have that there were obligations which were violated, but nonetheless it accepts the explanation. So much more to talk about it, I guess.
Yes, maybe just a closing question then to wrap up the discussion. Since you both touched upon the fact that the court is very inconsistent in its use of beyond reasonable doubt, this is also something that we see in the literature around beyond reasonable doubt at the European Court of Human Rights. Do you think, and you have both kind of touched upon this, but do you think beyond reasonable doubt as a standard of proof has to go, or can the court still rely on it? But if it can, then under what conditions would beyond reasonable doubt function well for human rights adjudication?
Okay, I'll go first. I refer you to my article on beyond reasonable doubt, but basically I have the 10 conditions in front of me that should be respected by the court, and then no problem with beyond reasonable doubt. It has to be sui generis, nothing to do with the common law. It must accept inferences. Third, these inferences must be drawn in practice. If there are strong presumptions and inferences, the court should not even hint that there might have been a shift in the burden of proof. It should recognize that it has been proven beyond reasonable doubt. It should be much clearer when it applies beyond reasonable doubt to the applicant, because at the moment it's not exactly clear. The commentators completely disagree. They come up with all kinds of different assessment of the case law. So obviously there is lack of clarity. Otherwise, we wouldn't have this complete disagreement. It should also say, and that's something I have touched upon, when BRD is imposed on the respondent state. I think there are situations where it should also be imposed on the state. It should also stop saying that it has only one standard of proof. Of course, there are multiple standards of proof, each of which is fit, applicable, must be used in different circumstances. So there should be more clarity on that. Of course, it should always be inspired by the protection of human rights. and it should stay away from using evidence, in a sense, as an appeasement tool towards states. So these are my 10 conditions.
And Christine, you said you changed your mind about BRD and whether it should be applicable. So could you tell us a bit about that?
Yeah, sure. So my reservation about having the beyond reasonable doubt standard is because it's such a high threshold of proof. And because of the power dynamic and the relative strength of the state, which often controls a lot of the information, this puts the applicant at a considerable disadvantage. So because I've said, well, the standard of proof links actually to who has the burden of proving the case, and this being drawn across as opposed from a sort of common law understanding of, oh, well, you have to prove that somebody is guilty of a crime. It's different if you've got a state that is potentially violated somebody's human rights, and the person has to prove to such a rigorous and exacting standard that yes, their rights have been violated. That's very difficult to really accept. However, the context has shifted. The court itself is vulnerable, and the convention system itself is vulnerable. If just to the political challenges that are coming its way, and so actually having such an exacting standard, and I'll talk in a minute about whether I think there's different standards of proof, but where it has met such a high standard that use of presumption and shifting the burden of proof if the state is being uncooperative is acting as a leveler of sorts. And so it's an attempt to actually force the hand of states that you can provide this evidence, why don't you, or we're presuming against you. But there is still a lot of information that has to be deemed credible by the court before it will do that. But because of that, that kind of, I suppose, the political context and the context within which an international human rights court finds itself, actually to be able to meet such a high burden of proof, where it's being applied virtuously, I use your term there, but whereas being applied virtuously and consistently actually is a very strong argument. This is a really credible court. It has the legitimacy. The judgment is sound, and it's doing the job of a court where it is making this evaluation to that level of certainty. This has happened. It's the facts that proof of those facts kicking into a finding of a violation. If I may then, with regard to that whole thing about different standards, I'm very clear that where the court declares its standard of proof, that is beyond reasonable doubt. But there are different ways that we might conceive of, what is proof, or what is the standard of proof. In a lot of the literature where it's referring to different standards of proof, we're talking about proving different things. We're talking maybe about qualified rights, and persuasion of an appropriate balance having been struck, rather than proof of facts proper. And where we're in the realm of, and I said, when it declares its burden of proof, its standard of proof as being beyond reasonable doubt, we're generally talking about facts which are being contested, and the state's not providing enough information. They're acting actually in bad faith, being obstructive, and we're talking about those really, there's really core points of has somebody's life been taken? We're talking about disappearances, talking about torture. That's where it's referring to its standard of proof. I think absolutely, I agree. It should acknowledge it has more than one standard, but that's because of the different rights that are involved and the context of the rights, of what's needing to be proven. So proving facts to then prove the case is different to proving that persuasive dimension, a wider point that applies to different cases maybe. And the other way that we might think, well, there's a different standard, non-refoulement cases, before a person has been returned somewhere, you're looking at the probability of somebody being harmed, not the concrete fact that they have been. And so you've got a different level of proof that you're looking for. You're not looking for proof at all. You're looking at a level of persuasion that this is a risk. This is a real risk. And so there's that dimension also.
And the one I would add as well in terms of variations of standards of proof is that it depends on the stage of the proceedings. So at admissibility, it should only be prima facie, and then at merits it can go up. Well, it must go up, but it's important as well that this is not the standard which is applied. That BRD is not the standard which is applied right from the beginning.
And I agree also from a point of pragmatism that the court isn't going to change that as its standard. So I think that's another thing to be conscious of. There is go, oh, actually, we're going to change. That's not going to happen. So I think that also is something to add into the mix, as well as the credibility and the legitimacy of it. This really is a violation. Actually, I think the pragmatic argument holds a lot of weight also.
Definitely. Okay, on that very positive note, maybe we wrap it up